welcome to the Kenneth Vercammen Legal Podcast. In this edition, we look at the arrest for possession of marijuana and possible defenses. Someone's arrested, the best thing to do is not make a confession. Don't permit a search. Don't confess until you say nothing and ask to speak to your attorney. If the police see things in plain view, they have a right to seize them. However, they don't have a right to search a car unless there's some type of either search warrant or probable cause. They certainly can't go into a trunk unless they have search warrant or consent to search. Someone's arrested. What happens? They're brought to the police station, they're fingerprinted, they're booked, they're given a summons, and there's a court date scheduled. That's when you want to contact the attorney. What will the attorney do? Well, the attorney prepares a letter of representation to the court saying we're pleading not guilty and also asking that the initial court date be waived. They're also preparing a discovery request to the prosecutor asking for copies of the police arrest records, any reports. Also, they're asking for lab reports because even though everyone knows what was found is marijuana, the prosecutor has to provide what's called a lab report where it was analyzed by the state police lab or another lab to prove it's marijuana. Discovery is received. Defense attorney can then file an objection to the lab report saying that they're requiring the chemist to come in. Defense object to the chain of custody and require, in some cases, that the prosecutor be required to bring in the police officer who arrested the person, the police officer who took the marijuana, the one who secured it, the one who drove it to the state police lab, and the chemist. That becomes work sometimes for the prosecutor. Now, for someone who does not have a prior arrest, there's a program in New Jersey called conditional discharge. That's for first-time offenders. Conditional discharge is where you're not pleading guilty. You enter the program, you're paying fines, fees, and a deed or penalty of approximately $800, but the judge is not required to suspend someone's license. It doesn't go on someone's record as a conviction, and at the end of the year, the charges are dismissed. So that's a conditional discharge. Let's say if it's a case with a higher amount of drugs that's in the Superior Court, then someone can apply for what's called PTI, pretrial intervention. But again, it's a one-time thing, and if you use up your conditional discharge, you can't get PTI down the road. Someone's not eligible for PTI, conditional discharge, then you need to contest it to avoid the criminal conviction. Occasionally, though, there's not defenses. If someone is pleading guilty, the attorney can file a motion to avoid the mandatory loss of license because in New Jersey and most states, there's a suspension between, driver's license suspension, between 6 months and 2 years, even if it had nothing to do at all with the car. But there's a new law and a case called Bendix that says that the defense attorney can file a motion and prove extreme hardship to avoid the loss of license. Typically, though, the person might be put on probation. So, again, the important thing, if someone's charged with a drug offense, don't wait. Get a good lawyer. Don't go to the cheapest person who's in the phone book or someone who sends you a letter in the mail. Get someone who has some experience handling these kinds of things and also knowledge of who the prosecutor is, and that court is always helpful. There's other articles on defense to drug charges on website njlaws.com and also on the website benotguilty.com. That's benotguilty.com for other information or representation. Call the law office of Kenneth Vercammen at 732-572-0500. Thank you and good luck.